As we move into Tier 2 studies, the focus will be on landowner outreach, very detailed environmental and engineering studies. And those studies are one of the reasons why you're all gathered here, because those are going to be impacting some of your properties. And so what's going to happen, once we get through the Tier 1, which in Tier 1 we've identified B3 as the corridor that we're going to be studying in greater detail. It's as you probably well know, it's a 2,000-foot wide corridor from I-55 to I-65. What we're going to be doing in Tier 2 is we'll be identifying the best 400-foot wide corridor within that 2,000 feet. And so at the end of that, we will have identified where the road, if there is going to be a road, would be built. We're going to be coordinating with you, the landowners. Part of the effort is we're going to need to understand the farm operations so that we can avoid as much as possible impacts to the way the land is being farmed. We're going to be coordinating with the schools, emergency service providers, the road districts to identify who uses what roads and which roads, and use that information to identify what roads may be closed and which roads will be kept open. As we plan for the future, land planning activities will also occur in Tier 2, with the study team working closely with the county and municipal planners to prepare the area for the continued growth in the region. We will be looking for ways to mitigate the impacts and enhance sustainability with the identification of feasible land management strategies. Another thing that will be looked at and developed during Tier 2 will be a financial plan for the project. The project will not be approved by the Federal Highway Administration without a feasible financial plan. MAP 21, which is an acronym for Moving Ahead for Progress in the 21st Century, which is the current federal transportation bill that was signed by President Obama in July of this year. That provides for various funding mechanisms for highway improvements. IDOT and MnDOT are both looking at innovative financing mechanisms to potentially fund the project. One of them being P3, public-private partnerships, in which case the outside entities come in and invest in the road, they build it, and there can be any combination of it, building it, operating, maintaining it, and those are going to be looked at in greater detail on a separate track during the next year of whether or not there's somebody out there that wants to invest in a 46-mile roadway through Will County. So that's all the stuff that you pretty much knew. Now you're going to get into the information on what's going to potentially be impacting you with the land acquisition information and the people there. And we'll be here to answer all whatever questions you have. Right?
Good evening, everyone. My name is Michael Harris. I'm from the Illinois Department of Land Acquisition, District 1, out of Schaumburg. Along with me, we're tonight is Chief Derka, and we also have Steve Andrews out of Ottawa. As of right now, since land acquisition impacts are not yet determined, I would like to reiterate that this is predominantly an information session on the land acquisition process. Land acquisition, IDOT's priority working with landowners to minimize property impacts. Landowners have the right to receive just compensation and acquisition of their property if required. Just compensation is the fair market value of the property and damages, which is loss of value, to the remainder of the property if only a portion of the property is required. If the acquisition requires relocation, the landowner may be eligible for reimbursement for reasonable and necessary moving expenses and/or supplemental housing payments. When the land acquisition occurred, as Cassidy already explained, after Tier 2 ROD is issued, estimated around spring 2014, when the funding of land acquisition is obtained, there is a possibility that some hardship acquisitions could occur before Tier 2 ROD receipt if funding is available. Now, the land acquisition is broken into 4 parts. The first part is when we determine property ownership. What we do is we will get a survey done and have title searches to verify ownership. Second is an independent appraisal process, which will take 3 to 4 months, when we hire appraisers, independent appraisers, to go out and appraise the property and provide fair market value. Third process is when the offer is made, and that is the negotiation process. As you see on the screen behind me, that is the offer, where it says offer accepted. That is when the negotiations are in process. Negotiations take approximately 60 days to accept an offer. There's a review process, clear title process, and we then order money, which the whole time frame is roughly 2 to 4 months. If the offer is declined, we get into the fourth phase, which is condemnation proceedings, which can take 12 to 36 months or more. The time frame can be shortened as we get into the quick take process. I'm going to go on to the next screen to explain the timeline a little bit better. Step 1 of the process. Again, we determine the ownership, and that's property survey, which takes 3 to 4 months. There's a plan of highways, which is prepared. Step 2, independent appraisal process, which takes 3 to 4 months. Appraisal will be done by an Illinois certified general appraiser or just a certified appraiser. There are 2 types of appraisers here, which is not quite mentioned correctly there. The review will be reviewed by a review appraiser, which is most likely going to be a certified general appraiser, who is a higher level of appraiser, the highest level of appraiser you can get. Then we will determine the fair market value. Negotiations will take 3 to 6 months. So I think I'm slightly off the other slide. It said 2 to 4 months. It's actually 3 to 6 months. Sorry about that. Negotiation takes 3 to 6 months. Negotiations begin with an offer equal to the appraised value. Once an offer is made, you have a minimum of 60 days, but typically more than 90 days to reach an agreement. If an agreement is reached, the following takes place, which is a 2 to 4 month process. And then that 2 to 4 month process includes the processing of the conveyance documents, review process through our Office of Chief Counsel. There's a clear title, all documents are then presented, and money is ordered. Transaction is complete within that 2 to 4 month time frame. IDOT's goal is to reach a willing agreement with landowners. As such, the negotiation process may involve multiple rounds of information sharing. If settlement cannot be reached to clear title, ownership cannot be obtained, the matter is referred to court for condemnation proceedings. Step 4, should condemnation become necessary, the 12 to 36 month process. As part of the legal process, either must prove that there is a need for the property and the basis for the proposed compensation to the landowner. The landowner can agree to settle or present their case, and ultimately the court decides the final compensation that will be paid to the landowner. The schedule for acquiring property through condemnation is based upon a particular court calendar. Therefore, could potentially require several years to acquire property. Okay, should quick take become necessary? This quick take would occur if the Illiana Corridor project is funded in IDOT's multi-year transportation program. Quick take involves the same basic process as condemnation with one exception. If IDOT demonstrates that there is an immediate need for the property at a quick take hearing, the judge assigned to the case by the court will set a preliminary compensation amount. This allows IDOT to obtain title, ownership of the property, and to proceed with the project while the future trial date is being determined. The property owner will be paid preliminary compensation amount shortly after the quick take hearing, but retains the right to trial to ask the court or jury to award additional compensation. Once IDOT has title to the property, IDOT will send out a notification to the property owner stating a specific date by which the property must be vacated, minimum of 30 days. Once the trial is held, the jury determines the final compensation. If it is more than the preliminary compensation, IDOT must pay the difference plus 6% interest from the date IDOT takes title. Ownership of the property of the date of ownership of the property to the date of the additional payment. One thing I need to add on there too is on that statement about the 30 days, there is also, the department may extend that 30-day time on a case-by-case basis once we determine the reason to extend that time. And that would conclude the process. Now I think we're going to open the floor for questions.